This is Barry Zalma speaking for Claim School Incorporated's newsletter, Zalma's Insurance Fraud Letter, for April 15, 2024. This Volume 28, Issue 8 of the newsletter is available free to anyone who subscribes by clicking on the link in the blog that is referencing this video. The newsletter is designed to be, and I believe is, the source of information for the insurance fraud professional. The newsletter contains many articles and is available free in Adobe PDF version by clicking on the link in the blog post. The articles include an article that is titled "No Reason to Release a Convicted Arsonist Early" in United States of America versus Jonathan Paul Wiktorchik, Jr., the United States Court of Appeals for the Third Circuit on March 25, 2024, found that the federal prisoner Jonathan Wiktorchik, who had appealed an order of the district court refusing him compassionate release, was an appropriate decision of the district court in denying the compassionate release. You can read the full article in detail and in Adobe PDF format, as well as the complete issue of Zalma's Insurance Fraud Letter at the link provided. Then there's an article on McClenny, Mosley and Associates issues, this being the 26th installment of the saga of McClenny, Mosley and Associates, MMA, and its problems with the federal courts in the state of Louisiana and what appears to be an effort to profit from what some magistrate and district court judges indicate may be criminal conduct to profit from insurance claims relating to hurricane damage to the public of the state of Louisiana. The first notation deals with a report from Matthew Monson, an attorney in Louisiana, dated on March 11, 2024, that Mr. McClenny sold to Mr. Mosley the firm, and new details were revealed in a recent court filing, showing that the deal to sell the firm was effective on March 31, 2023. Then there's an article about a new book available, the Compact Book of Adjusting Property Claims, 4th edition, which is available since January 2, 2024, and contains updates and clarifications from the first 3 editions, plus additional material for the working adjuster and insurance coverage lawyer. You can read the full issue of ZIFL at the link provided in the blog, and you can obtain the book through the insurance claims library at zalma.com or from Amazon.com. Then there's an article on Never Rely on an Application for Insurance, where it becomes clear that concealing or misrepresenting material facts requires rescission, at least in Alabama and other states. Allied World sued in Alabama general liability insurer concerning policies issued to Clint Lovett and his companies for the policy periods March 16, 2018 to March 16, 2019 and 2020. Allied World sought a judicial determination in its favor that it does not owe the Lovett defendants a defense or indemnity regarding 2 cases. The report of the case was entitled Allied World Surplus Lines Insurance Company versus Lovett Properties et al., a decision of the United States District Court for the Northern District of Alabama on March 15, 2024, where the United States District Court resolved the disputes. You can read the full article and the full issue of ZIFL at the link provided. Then there's an article entitled Pro Se Plaintiff's Qui Tam Suit Fails, and is subtitled A Private Citizen May Not Compel Enforcement of a Criminal Law. Ronald Rothman appealed from an order of the district court dismissing his complaint with prejudice and remanding a foreclosure proceeding in state court. In a case called Ronald Rothman versus Cabana Series 4 Trust et al., the Third Circuit Court of Appeals on April 2, 2024, resolved the dispute and prohibited Mr. Rothman from filing a qui tam suit as a pro se plaintiff. Then we have articles on health insurance fraud convictions, starting with how Holly Health Care Services, LLC, and its owner were sentenced to 3 years in federal prison for health care fraud. Julius Beccari, age 46, of Springfield, Maryland, was sentenced to federal prison, followed by 3 years of supervised release for conspiracy to commit health care fraud in connection with a scheme to fraudulently bill Medicaid. The defendant's conviction stemmed from a scheme involving services provided by Holly Health Care Services, a mental health service provider with locations in Washington, D.C. Federal Judge Zinnes also ordered Beccari to pay restitution in the amount of the loss, $3,343,781, because they billed for services that were never performed. The sentence was imposed on April 9 of 2024. You can read about this full article about this conviction and dozens more at the full issue of ZIFL, which you can download at the link provided. Then there's an article I wrote about arson for profit, because arson for profit is the most egregious form of insurance fraud. Perpetrators of an arson for profit scheme do not consider the fact that arson can cause residents, neighbors, police, or firefighters to be injured or killed. Claims based on an arson for profit are based upon the lack of intelligence or ability of the arsonist that we catch, because they don't realize a fire will not destroy everything. You can read the full article and the full issue of ZIFL at the link provided in the blog. Again, we note a new book available from Barry Zalma called Property Investigation Checklists Uncovering Fraud, 14th edition, which provides detailed guidance and practical information on the 4 primary areas of any investigation of suspicious claims. The newest book joins other insurance claims, insurance fraud, and insurance law books by Barry Zalma, all available at the Insurance Claims Library, which you can view at the link provided. Then, for a break, we have a fictionalized true crime story of insurance fraud called The Tiffany Kid, and it explains how, in detail, a rich kid became an insurance fraudster and was eventually caught after more than 20 years of success at fraud. The insured had grown up with his wealthy parents on the shores of San Francisco Bay in Marin County. He wanted for nothing that money could buy. He was tall, blond, blue-eyed, and handsome. Debutantes pulled their sisters' hair for the chance to dance with him. Life was good, but dull, and to relieve the dullness, he entered into a series of crimes. You can read the full story on ZIFL at the link provided. Then we have an article other than health insurance fraud convictions, starting with the story of a Benicia contractor who pled guilty to insurance fraud for underreporting nearly $1 million in payroll to his workers' compensation insurer. Kent Bo Friedlifson, 67, of Benicia, pleaded guilty to 6 charges of insurance fraud and grand theft after a joint investigation with the California Department of Insurance, Solano County District Attorney's Office, and the Employment Development Department revealed he underreported payroll by nearly $1 million to illegally save on workers' compensation insurance and taxes. Friedlison was placed on formal probation, ordered to pay $725,000 in restitution, and ordered to surrender his contractor's license. You can read the full article about Mr. Friedlifson at the link provided, along with the full issue of Zalma's insurance fraud letter. Then there's an article on insurance fraud schemes, where every claims person and SIU investigator must be aware of the various schemes used by insurance criminals to defraud insurers. For example, the National Association of Insurance Commissioners identified dozens of common schemes that result in the crime of insurance fraud. You can read about all of those schemes on the newsletter by clicking on the link for the full 18-page Adobe Acrobat issue. Thank you for your attention.